Madam Clerk, call the first case.
We have one case for Rule 20 argument this morning. State XRL Judicial Investigation Commission versus the Putnam County Board of Ballot Commissioners et al. Docket number 16-0223.
May it please the Court, I'm Brian Lanham, Deputy Counsel for the Judicial Investigation Commission. Mr. Troy Sexton is not legally fit to have his name on the ballot as a magistrate for Putnam County. Mr. Sexton has been convicted of several crimes involving moral turpitude, which make him ineligible to run as a candidate for magistrate. One of those crimes involving moral turpitude for which he's been convicted is a false 911 call. Mr. Sexton...
Ask you, that's statutory, right?
What statutory, sir?
The moral turpitude requirement.
Yes, sir.
Is there anything in the Constitution that prohibits him from running? Is this an unconstitutional statute?
No, Your Honor. There's nothing in the Constitution. The Constitution...
Well, how can the legislature prohibit him from running then?
Your Honor, the Constitution gives him the right to be a candidate, but this Court has held that giving a compelling and legitimate state interest, that right can be restricted, and the legitimate and compelling state interest in this case is the integrity of the judiciary. So the Constitution has not limited his right, but did give the power and the direction to the legislature to issue requirements. There are several requirements to become a magistrate.
Is that like a lifetime ban, or can you rehabilitate yourself at some point in time and be able to qualify for office again?
I don't know that that's been addressed. I know there is some case law out there where a candidate was removed from the ballot for moral turpitude because she failed to file income tax returns. She was pardoned by the governor, and the court ruled in that case that that did not remove the block from her eligibility.
Is the felony burglary involved with going back to the Reds game?
Yes, Your Honor, but he was just charged with that. He wasn't convicted of that.
Now, so what do you say is the moral turpitude? Just the whole shebang together, or any specific part of it?
There are several crimes involving moral turpitude. The first one is the false 911 call. This court recognized that any crimes involving intentional dishonesty are crimes involving moral turpitude per se, and the false 911 call involves intentional dishonesty. The second one are the two convictions for domestic battery. The elements alone show that that crime should be a per se crime of moral turpitude, especially when you look into the facts behind the domestic battery incident, which were the victims were his two 6-year-old sons at the time. Finally, if you look at his record as a whole...
Well, let me ask you this. You know, it seems that the statute and the case law that is in our bailiwick here seem to indicate that the acts have to have occurred while he was in office for him to be removed from office. What do you have to say about that?
I think that's a correct interpretation, but we're not asking that he be removed. We're actually asking that he his name taken off the ballot, which is completely separate, a completely separate statute.
Well, is the standard the same for removing a sitting magistrate and removing somebody from the ballot?
Under the statute and under the Constitution, there are a lot more reasons that you can remove a state office holder than just a felony conviction or a crime involving moral turpitude. But the felony conviction and the crime involving moral turpitude are in some of the statutes for removing an office.
Can I ask you one more question? And it wasn't in your research, so I don't know if you would know it, but is there any other office that has a qualification of moral turpitude besides magistrate? I mean, House of Delegates or Senate or any other political office?
Yes, there's a statute. The statute under Chapter 50, Chapter 6, Article 6, Section 3, which applies to all state officers and office holders.
Well, I'm sorry. No, you go, Judge.
I'm just going to say, so if you have misdemeanor convictions and someone wants to run for the House of Delegates or the state Senate, the same requirements apply?
No, I'm sorry. I was misleading when I said that. The statute that I quoted, it says you can't have committed a felony or a crime involving moral turpitude is the removal statute for a state officer. There is no requirement for a state officer in order to be elected. Only judicial candidates or only magistrates.
How did this issue come to you?
Actually, Mr. Sexton was a complainant in another case involving Magistrate Lawrence, and so in our investigation and talking to Mr. Sexton, we found out that he had some prior crimes, and also he's been on TV. I happened to see that episode, and then he filed for magistrate. So that's how we found out.
We had any sitting magistrates who have committed any similar offenses? Did we have one that was charged with or convicted of any type of domestic violence?
Yes, Your Honor. I'm not sure how much that particular complaint is public, but we did have one recently that was charged with domestic violence on his wife.
Was he found guilty?
He did not go to trial. The wife did not want to prosecute, and the case was dismissed, but he has since resigned from...
I'm not really worried about him. I'm trying to see if the standard is consistent with the sitting magistrate engaging in conduct that you would equate as moral turpitude. Do you try to remove magistrates at your commission?
Yes, Your Honor.
Have you had any efforts that have been before us where you've tried to remove magistrates for moral turpitude?
No, Your Honor.
Or any other judicial officer?
Not since I...
And I assume that moral turpitude, does that apply to other judicial officers as well as magistrates?
The statute only says magistrates, but if a candidate were to run for circuit judge or for justice and having been convicted of a felony or misdemeanor involving moral turpitude, a writ of mandamus, I think, would follow from the JIC as well.
Based upon that same statute that says magistrate?
No, not based upon the statute. Based upon the requirements of the Constitution and just protecting the integrity of the judiciary in general. There is no wording that says someone can't run for justice or circuit judge or family judge with a conviction of a felony or misdemeanor for moral turpitude. But it would be the JIC's opinion that they would be barred from running as well, and we would follow it.
Under the Constitution, you said. What specifically?
There is nothing specific that says, if that's your question, there's nothing specific that says someone can't run because they've been convicted of a conviction. We would go under the argument that if you can be removed as a justice or a circuit judge for committing those crimes, then you shouldn't be able to run if you have that on your record.
Well, I thought we didn't have the authority to remove judges. We could only suspend them.
You could remove them from the ballot, which is what we would petition.
Oh, okay. I thought you meant removed from office.
But that's what the statute I was referring to. If the statute says that a judge cannot be convicted of a felony or he will be removed, then it goes to reason that someone who's been convicted of a felony can't run for that office, and we would file a writ under that theory.
Normally in other offices, all you have to do is be a qualified voter. So even after a felony conviction, if your rights are reinstated, then you're a qualified voter again. Then you're eligible for office, even if it's a felony. Is that correct?
That's correct.
Well, now, is there some case law that says that if a sitting magistrate commits some kind of a bad act, that then the people re-electing, that erases it? I think we saw a case like that.
I think you cited to that, and so let's say that's out there. I'm going to tell you that it is. And is that inconsistent with your position? And if so, should that case be revisited?
If you're referring to the Godby case, I don't think that candidate was a judicial candidate.
That was an assessor.
An assessor, exactly. Yeah, it was an assessor, and the court has recognized that the state and the legislature can put extra limitations on candidates for the judiciary that would not survive constitutional scrutiny if they were a candidate for some other branch of the government because of the compelling state interest of the integrity of the judiciary.
Let me ask you this. Is the moral turpitude, is it assaulting of the little children, or is it the placing of the 911 calls? Those are both bad acts, but they're real different kinds of acts.
Yes, Your Honor. The convictions for all three offenses, any one conviction makes him ineligible.
So in other words, you say it could be something that shows dishonesty. Now, beating your children doesn't show dishonesty.
No,
It just
Your Honor.
shows you've got a really bad temper and abusive personality.
Yes, Your Honor.
These children, they left them with him after all this?
He was removed from the home, and the DHHR went in and did an investigation. He was eventually allowed to return home after the case was disposed of.
Anybody got any other further questions? All right, sir.
Thank you.
Mr. Sexton, do you want to speak?
Yeah, my name's Troy Sexton. When I ran for a magistrate, I saw that moral turpitude clause. I saw there's really no set definition for it. And I figured the one thing that would be an obstacle was the thing with my kids in 2009. And when the facts, I guess I wrote a lengthy 26 pages to you all. When you look at the facts behind what happened that day, it's not what,
Well, you pled guilty, didn't you?
I pled no contest.
Okay. That's the same as a guilty plea in the eyes of the law.
Well, keep in mind, at that point in time, I'd been separated from my home for 4 months. I just wanted home. Was I guilty or not? I just didn't really care.
This is when you allegedly assaulted the kids or assaulted the kids.
Yeah, yes.
Well, why were you out of the home?
Because of the bail. It was a part of the bail bond agreement.
Okay.
And
Who do you supposedly make harassing calls to?
that would be my wife's family.
Okay. And you don't deny the 911 fake call?
No.
And you don't deny the Cincinnati Reds earning against a lifetime?
Yeah, I
Banishment.
returned with, I didn't cause a one problem at that game, and I certainly did not commit a felony burglary, which I was prosecuted on.
So your position is that while these may be misdemeanors, they're not misdemeanors involving moral turpitude.
Right, and I think I put in there, their argument was, moral turpitude regarding my sons was, they used some federal deportation definition about causing serious injury. Well, the facts are, my kids were not injured at all that day. They weren't seriously injured. Child Protective Services found the allegations of abuse to be false. To be false. Claims were made that weren't true, that were presented as fact. They were also forwarded to you from what I've read. And they've been presented as fact for 6.5 years that are not fact. The bottom line is, yes, what I did was wrong. I did not hurt my kids that day. They were not hospitalized. They did not go see a doctor. They didn't have to see any psychologists. And there was no bruise forming on any of them. That was a lie. Yes, it was wrong, but to prevent me from running from office for that, I totally do not agree with.
Okay. Is there anything else you'd like to add, Mr. Sexton?
I've written what I've written, and I have nothing else to add. Okay.
So we read. Okay. Well, all right, then have a seat, and sir, do you have a...
Excuse me, Chief, but Jennifer Carr from the prosecutor's office is here to argue on behalf of the ballot commissioners. She's a respondent in the case.
Oh, okay. I'm sorry.
Justice, at this court, I am simply here representing the Putnam County Board of Ballot Commissioners. In case you all have any questions, we do appreciate expediting this event. I would also mention that I was the assistant prosecutor that handled some of those earlier cases with this respondent, Troy Sexton. And I would additionally point out that those women he made the harassing calls to were 3 of which women who had written in letters to the probation officer while Judge Spalding was doing a pre-sentence investigative report. So it was a little more than just harassing calls. It was really retaliation.
Is that in the record?
I believe the convictions are. I'm not sure that the underlying facts are in the record.
Well, that's not very fair to Mr. Sexton. I mean, just bringing up facts. It's not in the record. So go ahead and proceed.
But that is I'm simply here for questions with regard to the ballot.
Oh, so you're not really I mean, you just presented that information, but you're not really taking a position on this.
That's correct. Our ballot commissioners simply look at the residency, the whether the person is properly registered, their political affiliation when they file their certificate of announcements. And that's as far as the Board of Ballot Commissioners go with regards to looking at the qualifications of a candidate.
Well, what about the requirement in that statute, I think 5311?
Our Board of Ballot Commissioners has never gone out to make judgment calls on the qualifications of people, except for what is on that, the four corners of the document, the certificate of announcement, and then also the official voter registration records that we have in the county clerk's office.
Well, are those in compliance with state law?
Are those, looking at those qualifications in compliance with state
Because
law?
it seems to me like there's another requirement, which is the entire reason we're here.
There is this requirement, however, it's of such, an important decision to make that the Board of Ballot Commissioners, they don't feel qualified to make that decision, because if they err on, say, either side, there are grave consequences. If you remove someone from the ballot, there's really no way to remedy that, if the Board of Ballot Commissioners is incorrect. So that's why we have deferred to you.
Determinations on all of the other factors. So, I mean, so what's the difference there? I mean, what's your role? What do you see as your role in certifying somebody to run for or to be on your ballot in your county?
Probably looking at an actual official record, where we don't exactly make judgment calls. We look at an official record, that a voter registration that's been filed in the office. That's an official record. The person lists the party that they're affiliated with. They list their residence. Then also that certificate of announcement that they have filed, they list those things. So
My question, have
limited.
you ever been convicted of a felony or misdemeanor?
Correct. No.
Well, what your position is then, if the Office of Disciplinary Counsel hadn't stumbled across this, Mr. Sexton would be on there without any opposition or objection, because your office is not going to take a position.
That's correct.
Ever?
I will say they never have, and they have chosen not to do so in this case.
Okey-doke. Thank you, ma'am.
Thank you.
Mr. Lanham?
Your Honor, I don't have anything else unless you guys have some more questions.
That's a good argument. Thank you. Case will be submitted. Marshall?